Okay, good morning, everybody. Welcome back to this episode of the Wilton Report. And today, we're going to be talking about the very exciting New Jersey-led SAFE certification law. This podcast, this video vlog, as it were, is really directed at landlords and or people who want to be landlords in the state of New Jersey, because effective July 2022, there is new legislation that was passed that will impact how you run your investment properties. So what is the new law? So it's a little bit onerous for landlords and actually very onerous for municipalities, in my opinion. But so what it is this. Beginning July 22nd, 2022, lead paint inspection and remediation will be required for residential 1 and 2 family rental properties upon tenant turnover or by July 24th, 2024, if there is no tenant turnover. So if you have a long-term tenant, you will have to get that property inspected. If you have leases running past 2024, if your property turns over between now and July 24th, 2024, you will have to have this lead-based paint test. And there's a couple of different tests. Who runs it, how it's done, that's what we're going to talk about today in a little bit of detail. And then, we'll keep you posted of news as it comes. So first off, July 22nd, 2022 requirements. Rental properties subject to the new law must be inspected upon tenant turnover or no later than July 22nd, 2024. The type of inspection will depend on the lead levels in the children in the municipality where a rental is located. We will talk about that in a little bit. Remediation requirements. Properties where lead is found during an inspection will need to undergo remediation, either to make it lead safe or lead free. There is a difference. One is more costly than the other. Measures to temporarily make a property free of lead paint will make it lead safe. Measures to completely eliminate lead paint will make it lead free. So there's 2 levels of inspection or remediation that can be done. So what are the requirements in municipality? So obviously our little firm is located in Princeton. We do business all over the state, but taking Princeton as a hypothetical example, and it could be Montclair, it could be anybody. The law imposes an obligation on municipalities to perform or hire a certified lead evaluation contractor to perform inspections of certain single-family, 2-family, and multiple rental dwellings for lead-based paint hazards every 3 years or on tenant turnover, where there is no valid lead-safe certification. So, municipalities must permit dwelling owners and landlords to directly hire a certified lead evaluation contractor for this purpose. So there's a lot to this law. It's going to impose a big burden on municipalities and a burden on landlords. Not bad intentions. This is not a political podcast, but there is going to be a couple more steps to step through and some more liability as a landlord in the state of New Jersey. So what are the requirements of property owners under PL 2021 C182? That's the name of the law. If lead-based paint hazards are identified, so if you have a rental unit, the municipality comes in, does an inspection, then the owner of the dwelling shall remediate the hazards through abatement or lead-based paint hazard control mechanisms. So we'll talk in a little bit of detail because the law's a little murky there. Property owners must report all tenant turnover activity to the municipality. That's a big shift, a big shift. Lastly, property owners must provide a copy of NJAC form, any lead safe certifications, and accompanying guidance document to any prospective owners of the dwelling during the real estate transaction settlement or closing. That's always been part of the real estate transaction. However, it's going to be much more stringent. So, again, landlords, you definitely have a couple extra steps to go through as you turn over your rentals anywhere in the state of New Jersey. So what does the law apply to? What dwellings will be inspected? All single family, 2-family, and multiple rentable dwellings must be inspected. The following dwellings are exempt. Obviously, anything constructed after 1978. That's when lead-based paint was outlawed in the United States. So any new construction after that does not have to be inspected. Single family, 2-family, seasonal rental dwellings, which are rented for less than 6 months duration each year by tenants that do not have consecutive lease renewals. So meaning this, the shore area, properties at the lake, probably Airbnbs fall under that part of the statute. Or dwellings that have been certified to be free of lead-based paint pursuant to the law. Multiple rental dwellings that have been registered with the Department of Community Affairs for at least 10 years and have no outstanding lead violations from the most recent cyclical inspection formed under the multiple dwelling law. So if you have a 10-family unit, and basically if you're lead-free, you've been proven you're lead-free, I think you're exempt under this law. And a multiple dwelling that's been registered with the department for at least 10 years with an open inspection and has no violations for paint is also exempt from this requirement. So there's a lot to this law. There's a lot to understand as landlords, and we're gonna continue to break it down. This is more of an overview. So this is where I think it gets really interesting, because if you're a landlord and you have properties in 10 different towns, you could have 10 different standards, or one standard per town, I should say. So what's the periodic inspection procedure? And again, that's the burden of the municipality. For dwellings located in a municipality in which less than 3% of the children tested 6 years of age or younger have a blood level greater than or equal to 5 micrograms per deciliter, the inspection may be carried out through visual inspection, meaning the municipal inspector will come in, eyeball the property. If there's no dust, flakes, paint chips, etc., I assume, right? That would be the inspection. However, for dwellings located in a municipality in which at least 3% of the children tested, 6 years of age or younger, have a blood level greater than or equal to 5 micrograms per deciliter, the inspection must be carried out through dust wipe sampling. So why is that? Because if I have lead in my house and it's peeling and flaking and turns into dust, it will go in the carpets. It will get on the floor. People walk barefoot in their homes. It gets absorbed into the skin. That's actually a big problem in the state. So the last one, all rental dwelling units required to be inspected must be inspected for lead-based paint within 2 years of the effective date of the law. So there is a timestamp on this. And then it's every 3 years after that. So that's the periodic inspection procedure. A visual assessment is an examination, right? They're going to look for paint chips. They're going to look for painting activities that were not cleaned up, paint residue on floors, right? So the standard of practice, the standard of being landlord is going to go up. What are dust wipe samplings? Dust wipe samplings is collected by wiping a surface, right? And doing a test in accordance with HUD, Department of Housing and Urban Development. So that's I would say a more onerous test, and the probability of lead coming up in an older home is going to be much higher on that. So what does that mean? It means get your houses painted, get them updated, get them scraped professionally with a lead-based painter, certified painter. So what investigations are required under the Act? Again, this is going to add a whole layer to any municipality. So they're authorized to conduct investigations and issue penalties to enforce a property's owner failure to comply. So if the municipality determines that a property owner has failed to comply with the requirements of this law, the property owner must be given 30 days to cure any violation. Now, here's the issue. Contractors in New Jersey are absolutely booked out. There's not that many lead-based paint contractors, remediation companies. I looked. So if this is, the route you're going to go and you want to remediate and get the jump on this, I'd book a lead-based contractor now, not wait. So what are the penalties for landlords? So it's not cheap, right? It's $1,000 per week if you have not remediated the finding within 30 days. So if the dwelling owner has not cured the violation within 30 days, the owner shall be subject to a penalty not to exceed $1,000 per week until the required inspection has been conducted or remediation efforts have been initiated. And again, that's the onus now is on the landlord to report everything to the municipality. So if the municipality has not cured the violation within 30 days, they shall be subject to a penalty not to exceed $1,000 per week. So like I said earlier, this is very onerous on the municipalities. This is very onerous on landlords, but it's, with really good intent. So what does that mean? Well, as always, you obviously want to stay informed. We'll be reaching out to you with more information on this law because I think it does change the scope of what it means to be a landlord in New Jersey. It's going to look a lot more like a job than it has in the past. And number two, it's our job just to keep you informed. So that's it for today. It's a very exciting topic of the Lead-Based Paint Act in New Jersey. Any questions, obviously, feel free to reach out. You can look us up on YouTube at The Wilton Report. Follow us on LinkedIn at Joshua Wilton and Instagram at JoshWilton71. So thanks, everybody, and I will see you next week.